Hello, welcome to today's live. Okay, what's the subject for today's live? It's going to be H-2Bs and specifically how H-2Bs apply to domestic help. Okay, what the pitfalls are, how to do it, procedures, and so forth. Okay, so once I'm done with that, what I will do is I will come back, answer whatever immigration questions you have. It has to be U.S. immigration. If you ask me stuff on New Zealand or Canada, I'm most likely not going to be able to help you. But anything related to U.S. immigration. All right, so let's get into it. So, what is the H-2B? Well, it's a temporary, really temporary, okay? As a matter of fact, when I do the attorney cover letters for the H-2B, I have to make sure that it is specifically described how the temporary, make sure that it is specifically described how the temporary a one-time occurrence or whether like it's the end of the year audit, whatever it is. So how does the H-2B work if it's with domestic help? Okay. First of all, there's a lot of fraud with that. There's a ton of fraud with that. So if you're going to try to bring in somebody for domestic help, you're going to have to get over the what is perceived to be the fraud element, okay? Because immediately Department of Labor, they're going to think the only reason you want to bring this in for domestic help H-2B is because you have some relationship with them and they're thinking you want them to come here and then ultimately, maybe marry or, adjust status, whatever it is. So it has to be a real temporary need for domestic help, and it has to be a real need. Okay, so let me give an example. Let's say that you want to bring somebody in for domestic help to help clean, to help, do the dishes, to help cook, to be sort of like a caregiver. And you say, you're getting old and you just need to have have someone around for that to help you. That, first of all, is, minus the fact that it may or may not be legitimate, that's not going to work for the H-2B because it's not temporary. Okay. If you just say that you're getting old and you need this help, where's the temporariness? If you need it now, you're going to need it a year from now. So let me give you another example. Let's say that you have to have your hip replaced. Okay. And let's say for maybe 6 months, you're going to be recovering. You're going to be doing rehabilitation. You're going to be getting stronger. You're going to be learning how to walk again. Whatever it is. And let's say that you do an H-2B because you know that you're going to need that help for 6 months. Okay, that is much more realistic to try to get an H-2B than just saying, well, you need someone to come help. Okay, that's the reality. So when you're doing the H-2B, obviously, if there's some relationship between you and the person that you're doing the H-2B, it's going to be very difficult to get approved. If you can't show the temporariness, then it's not going to be approved either. Okay. Now, there is on the other side of it, there's the green card where you could petition someone for domestic help, and that has all kinds of issues as well. But in that regard, you have to prove it's permanent, not temporary. It's sort of the opposite. Okay. So when you're doing the H-2B for domestic help, one of the difficult things you also have to get over is initially you have to do what's called a temporary labor certification. You have to show that there's nobody in the U.S., U.S. citizen or resident or someone authorized to work, who has the qualifications to do the job. And while, it certainly can be done, it's difficult to show. Let me use my hip example again. It's difficult to show that you will not be able to find somebody in the US through the advertising and the normal means that are necessary to try to get someone that they are qualified, or that they're not qualified for the job. So even if it's a legitimate position and even if it is legitimately temporary, you still have to prove through the initial process that there's no available US workers for the position. Okay? Now let's assume that you can do that. Then you have to show and pay the prevailing wage. What's the prevailing wage? Well, they say it's what is normal for that position, but I have found in the past that when I look on the governmental sites of what is, quote, prevailing wage, it normally is considerably higher than what you think it might be. And you'll be required to pay that. So if, for example, you put an ad in the paper, let's just not talk immigration. You put an ad in the paper and you put an ad for, some kind of domestic help for 6 months to help you do things and we'll get around and whatever because you had your hip replaced. And let's say they say, well, they're going to charge you $25 an hour, whatever. But then let's say you petition someone and that might not be 25. The prevailing wage might be 29 or 30 an hour, something like that. And so you're going to have to pay that in order to petition them in. Okay? So that, in essence, is what the H-2B for a temporary position is, okay? And for domestic help. That in a nutshell. So it's not easy to get in, okay, but it's doable. One more thing. There's only 66,000 H-2Bs per year, and that's divided into two. I mean, they issue 33,000 basically every 6 months. So in that regard, timing is everything here because if for example, your surgery for the hip is going to be 3 months from now, you have to look and see if there's any more H-2Bs left and get the wheel rolling, or you might have to wait until the next allotment, in which case maybe you'll be halfway rehabilitated before you can bring someone in anyway. So it's all a matter of timing. Okay? All right. Let us scroll back down here and see what questions we have. By the way, if anybody wants me to give them a consult on the live where everyone else can hear, go ahead and give me a holler. Let me know and I'll do that. Okay. Let's see. Hope everybody's doing well today. Let me just keep scrolling down. This is the time of the live where we have to be patient. Here we go. Oh my God. Some guy's asking me about the Epstein files. It's funny. Yeah, funny. Believe me, if I had them, they'd be in the public. Okay. So that wasn't an immigration question. It was humorous, though. I'll give you that. It gave me a little laugh. Okay, let's see. Okay, we have a question from Exodus Rose. By the way, I put a goal up for 5 roses. So, speaking of that, Exodus Rose, can you still apply for citizenship if you've had a green card for 8 years already but divorced? Yes, absolutely. What you're referring to, Exodus, is the 3-year exception to the normal 5 years. Okay, let's say you're married, you get petitioned through marriage, and you want to become a citizen. You can do it after 3 years of marriage. Okay, that's much quicker. However, you've already had the green card for 8 years. You don't even need to use that anymore. You can just use the 5-year normal time in which to apply to keep the green card. You don't apply through the marriage way, okay? And so that doesn't mean you absolutely qualify. I would need to make sure that, you don't have any crimes or anything that might kick you out of naturalization and sometimes into removal. I've had that before. A lot of clients will call me when they're in removal proceedings, and they try to apply for naturalization only to find out not only was it denied, but they got put in removal proceedings. But just given, let's assume you don't have any of those issues, you just select the 5-year, okay, not the 3-year. Easy peasy. Okay, let's see. Do we have any other questions? Okay, this is from Ride AA. I received an NTA. You say ICE ERO. I'm not sure what that means. Appointment for removal. What should I expect? Okay. Well, an NTA is a notice to appear. That is the beginning document for removal proceedings. So what should you expect? You should expect that they want to remove you from the United States. Okay, they want to deport you. And just as an aside, you probably want to get an immigration attorney to represent you because they are not your friends. I mean, obviously, ICE is nobody's friend right now, except the people who want them to do what they're doing. So the immigration judge, the trial attorney, nobody's your friend. They're not there to help you. They're going to do everything they can to try to get you deported. So the immigration attorney will see what you qualify for. And I don't know. I mean, you might qualify for asylum, Convention Against Torture. You might qualify for adjustment. I need to know why you have the NTA. Did you commit a crime? I need to know if there's waivers. I mean, there's all kinds of stuff that I could look at to see what you might qualify for. But that's what you should expect, okay? It's not going to be an easy road. But do not sign the please deport me, I don't want to fight paper, because you're just making their life easy and your life hard. Okay? All right. Just a second. I got to... 1 second. I was scrolling and then it just went all the way to the bottom, so I got to get back up. Okay, there we go. All right. Let me see. So, I've asked this before, but sometimes it says invite so-and-so to join live as a guest. So is that because you want me to invite you to ask immigration questions and have a consult? Like, for example, Sadia, it says to invite you. Does that mean you want to have a consult and ask me questions live? I don't know. Let me know. Okay, let's see if we have any questions anymore. Okay. It looks like that's about it. Oh, wait. I think I passed one. Okay, this is from Moral. Derivative asylee apply for I-45 after 1 year of presence. Is the process faster than petitioner? I'm not sure I understand your question. I think what you're asking is if the petitioner who now has the green card petitions you in a normal family basis, is that faster than you applying as a derivative asylee because that's how they might have got the green card in the first place? Generally, yes. You should apply as the derivative asylee because, it also depends what preference family petition it is. But if you do just a regular family petition, you're giving up the derivation of being, of the asylum applicant, and you don't want to do that. So I would, and we could get into it why, but you should definitely apply as a derivative asylee. Take care of business and get it done. By the way, there's really no problem applying both of them, okay? And the first one that gets to the finish line wins. I mean, you could do that, okay? Does that make sense? All right, just a second. Okay. I don't know why it always scrolls to the very bottom when I'm scrolling. Okay, just a minute. All right, well, I think that does it. Okay, I think that'll do it for... Why does it keep popping up 2 new messages? Oh, wait, there it goes. Okay, so I think that'll do it for now. But, if you have questions and I didn't get to it, go ahead and text me or let me know. I think I have time for one more question here. This is from Ride AA. Okay, I had a previous asylum which was denied, for which I have applied for a joint motion to reopen. That's what JMTR stands for. I have an I-130 approved, 212 and 601A. If you weren't if I wasn't an immigration attorney, I would not understand that. So, first of all, it's good you have a joint motion to reopen. I mean, in today's day and age, to have immigration agree to reopen a case with you, 2 thumbs up to you. Okay, that's great. Because they're playing hardball up and down these days. Unless you've had the joint motion to reopen for a long time. I don't know. Okay, well, the 212 would be because you had a prior deportation order. Okay, and the 601A is it's a provisional waiver. Okay, and the 601A would be used if you're going to consular process. So there's certain issues with what you have just said which don't make a lot of sense, okay? Sorry, I misread it. You have applied for a joint motion to reopen. That's not going to be approved. There's no way, okay? I was like, I read it as though it had already been approved. There's no way. What you're saying here doesn't make sense. Just because you have the I-130 approved does not mean you qualify to adjust, okay? And if you already have a prior deportation order, the fact that you have an approved I-130 doesn't give grounds to do that. The path you're doing this, just from what you're saying, isn't really correct. If you have an approved 212 and approved 601A, that means you're consular processing, okay? You're going to leave. You're going to go to the interview, assuming there's no other grounds of inadmissibility, the 601A stands, and then you would come back as a resident. It's very, very unlikely they're going to grant the joint motion to reopen, in my opinion. Okay? There you go. All righty. How long does it take to get a T visa receipt notice? This is from Bad We Bad. That sounds like a song. You really shouldn't be concerned how long it takes to get the receipt notice. A couple months, that's no big deal. The real question is whether you qualify for the T and whether the T will be approved, okay? There's too many people that are just concerned that how long things take, without realizing that they could certainly be denied. So look at your T. If it's a strong case, that's great. There's no backlog of Ts. It's not great that the basis upon which you file the T is you were either trafficked in sex or work. So, a lot of bad stuff would happen for you to qualify for a T. But on the other hand, it's not like a U where there's a 10-year backlog. Okay? Alrighty. Let's see. All right. Well, I do have my own consults coming. Okay. Ride AA can message you. Yeah. Ride, just message me directly. Because if you message me directly, you can put the whole kit and caboodle there so I can see where you are and give you some advice. Okay? That's how that'll work. All right, everyone. It's been fun. Until the next live. Okay, everybody.